Yeah. All rise. Oyez, oyez, oyez. The Supreme Court of the United States is now in session. Presiding. All witnesses before the court. Be seated.
Well, good afternoon. We are here today to consider arguments in the matter of Mark Scout, petitioner, versus Douglas A. Collins, Secretary of Veterans Affairs, respondent, docket number 25-3561. Is our counsel for the petitioner ready to proceed?
Yes, sir.
And counsel for respondent?
Yes,
All right, you can begin.
May I proceed?
Absolutely.
Chief Justice, Your Honors, and may it please the court. My name is Elizabeth Bowers, and I, along with my co-counsel Hannah Hussey, represent the petitioner, Marine Corps veteran Mark Scout. Your Honors, this case is about a veteran who fought to protect our freedoms and is now being denied his own. Accordingly, petitioner respectfully requests that this court reverse the Federal Circuit Court of Appeals decision for two reasons. First, the VA mandatory medical exam policy is not neutral nor generally applicable. And second, it cannot meet the demanding burdens to which it is subject to under strict scrutiny. Which brings me to my first point, that the VA policy burdens Mr. Scout's free exercise of religion and is not neutral nor generally applicable. Your Honors, by way of background, Marine Corps veteran Mark Scout served at Camp Lejeune, where he was exposed to contaminated water, leading to his stage 4 chronic kidney disease. He was originally awarded an presumptive 80% disability rating that was increased to 100% following a kidney transplant. 1 year later, the VA required that he attend a mandatory medical exam, to which he objected to based on his religious beliefs, as you can see on the record on page 52.
Do we have any information about whether Mr. Scout ever previously objected to any medical examination?
No, Your Honor, the record is silent as to his previous objections. Here, however, he objects on religious objections to that specific exam.
To that specific exam. And so what is it about that specific exam, other than the fact that it might lead to the reduction of his 100% rating, that bothers Mr. Scout?
Your Honor, on page 28 and 29 of the record, Mr. Scout states that he has warded off Western medicine as it compromises his spiritual integrity in opposition of his sincerely held religious beliefs, to which is his objection to this medical exam and presumably any future exam of this style.
So what is it about the diagnostic criteria that makes it so basically you have Smith, right? Employment Division versus Smith as an example of what is a neutral, generally applicable law. And then, the most stereotypical example of the one that looks generally applicable but isn't is the Leukemia Babalu, a great name for a case. And so why is this more like the city of Hialeah, the case, than it is the Smith case?
Yes, Your Honor, this case is not neutral and generally applicable for a few reasons. First, because of the good cause exceptions that are included. And as you stated, Employment Division versus Smith is kind of the cornerstone jurisprudence for this neutrality test. And it states that when a law is neutral and generally applicable, it can incidentally burden religion constitutionally. However, when it is not, it is subject to strict scrutiny, as it is here. Additionally, Fulton versus City of Philadelphia stated that the Constitution forbids the government from singling out religious reasons. And when the religious conduct is offered disfavored treatment, then the law is not neutral or generally applicable. And more.
Why is religion disfavored on the face of the statute? I mean, right, in terms of the City of Hialeah case, leukemia, right? What it said is you can't sacrifice animals within the city limits, and then it gave all the exceptions that left only the Church of Santeria as the ones that couldn't sacrifice animals, right? And so what the Supreme Court said was that was targeting religion because the exceptions were so great that it left only that one particular Santeria church. How is the good cause exception anything remotely like that?
Your Honor, it's similar in the fact that it lists specific examples of circumstances. However, here refused to consider religion as a good cause exception. And in Fulton.
So when you say refused to consider, now you're talking about an adjudicator, right? You're talking about the board?
Yes, Your Honor.
Okay, but stick with the language of the statute or the regulation here. The mere fact that it provides, and you agree with me, the list of exceptions for good cause are non-exclusive.
Yes, Your Honor.
Right, okay. So why then does that regulation on its face lead to this idea of targeting religion?
Your Honor, similar to the case of Church of Leukemia Babalu, IA Incorporated versus City of Hialeah, as you stated, they specifically left out the Church of Santeria, and here religion is also specifically left out. And as Fulton stated, when
isn't the requirement for a mandatory examination a year after the transplant neutral on all but ascertaining the nature and extent of residual renal dysfunction?
No, Your Honor, it is not neutral and it is not applied evenly to every veteran. Here, while specifically leaving out religion, Fulton stated that when secular motivations are evaluated, so must religious ones. And here, that it was not, shows how it is not neutral nor generally applicable. And further, this specific good cause framework is one that was specifically condemned in Sherbert versus Werner because it stated that allowing secular excuses but denying religious ones destroys the basis of neutrality. And this VA has already recognized that individual exceptions are possible, but it simply excludes faith from such protection. For example,
how does it exclude, if it's a non-exhaustive list of exceptions, right? How does it exclude religion?
Your Honor, here it did exclude religion. It did not take Mr. Scout's objection as a good cause for religion.
Well, now you're talking about the board, right?
Yes, Your Honor.
Right, the board. But just again, sticking with the regulation itself doesn't exclude religion, right?
Your Honor, it's not written explicitly that it refuses religion, but this court, as it found in Church of Leukemia, leaving out just also destroys neutrality, as it did in that case.
Well, but how could something be left out if it's a non-exhaustive list of examples, and the examples that it does list are ones that are most likely to come up, right? You'd agree with me that the idea that something violates the First Amendment is really not the most common thing for a reason somebody is going to miss an exam, right?
Yes, Your Honor.
Right. And so it may be that the board misapplied this in a way that implicates a constitutional value, but it's I'm just having trouble seeing why the regulation on its face purports to do that.
Your Honor, this is also an as-applied case to Mr. Scout's circumstances. And here, that is an implication and a part of the analysis. As it was applied to Mr. Scout, it violated his First Amendment right by substantially burdening his religion. And further, in Fulton, this court states that this must be the rule, because a policy that grants discretion, as the one here, is not neutral nor generally applicable. And the standard has come...
Is it the petitioner's, is it the position that the problematic regulation is the rating regulation and diagnostic code, or the good cause exception regulation?
Your Honor, the VA mandatory medical policy that we are here to discuss today is 3.4115B. It is a mandatory medical examination. However, it works in conjunction with the good cause exception and the diagnostic code. However, the mandatory medical examination is the one that is considered, we believe, unconstitutional.
So under the good cause exception, is it your view that if a veteran shows good cause, they are excused permanently from attending an examination, or is it just a temporary reprieve?
Your Honor, while the good cause ones that are listed are only temporary, the VA also allows, in Nieves-Rodriguez versus Peek, the Veterans Court Board of Appeals, stated that private medical evidence can be substituted for such mandatory medical exams. And here, Mr. Scout provided that documentation, and it was rejected by the court. Here, Mr. Scout's objection is grounded in his sincerely held religious beliefs as defined in United States versus Seeger with his consistent practice.
Let me interrupt you there about whether this is a truly religious objection. You spoke to this somewhat earlier. Under some of the case law, we can look at whether or not there is a true religious exception, or whether it's a very bizarre assertion of religious. What do you make here of the veteran's repeated statements that he did not want to go to the VA exams because he considered the VA doctors to be quacks or unqualified? Is he refusing to attend the exam because he doesn't think they're competent, or because there's a truly religious aspect to this?
Your Honor, on pages 28 and 29 of the record, Mr. Scout evidences his consistent belief in this religion following his poor experience with the VA and his kidney transplant. And as this court stated in United States versus Seeger, while the court can look at evidence like that, in addition to factors such as inconsistency, secular motives, or opportunistic timing, none of those are dispositive factors. And here, the strong evidence points towards Mr. Scout believing that Western medicine harmed him through his kidney transplant, and now believes in following the fate of the cosmos as his religion, therefore objecting to this mandatory medical exam. And further, the court cannot evaluate the orthodoxy or reasonableness of this religion as held in Thomas versus Review Board, because courts are not arbitrators of scriptural interpretation. Which brings me to my second point, that the VA...
Can't the board evaluate the quality and quantity of the evidence that's submitted?
Yes, Your Honor. And as my co-counsel will say, that was a prejudicial error on behalf of the board, leading to the denial of the evidence that Mr. Scout provided to them. Which brings me to my second point, that the VA policy fails under strict scrutiny. When a policy is found to be neutral and generally applicable, then it is subject to the standards of strict scrutiny, which are laid out in Burwell versus Hobby Lobby, just as an example. The requirements of that are that there must be a compelling interest, and that the policy must be narrowly tailored and the least restrictive means of completing that compelling interest. First, the VA and the Veterans Court of Appeals, as well as the Federal Circuit, stated that their compelling interest was in the orderly management of veterans' benefits, and that can be found on page 7 of the record. However, as this court stated in Wisconsin versus Yoder, only interests of the highest order and those not otherwise served can overbalance a legitimate claim to the free exercise. For example, in Holt versus Hobbs, this court found that prison security was not a compelling interest, one that puts the lives of the guards, the inmates, and countless other people who work at the prison in jeopardy. Here, bureaucratic efficiency surely does not reach the point of putting lives in jeopardy. Likewise,
And so what about the protection of the public fisc, right? The American taxpayers. So somebody's going to get 100% rating. You mentioned to Justice Meredith that it's not a temporal issue, so apparently the person gets it for forever.
yes, Your Honor, while administrative efficiency such as that and the prevention of fraud has been accepted in the past, this case is not analogous with such cases and are highly distinguishable. For example, in United States versus Lee, this court stated that mandatory participation in Social Security was vital to the system, and it would jeopardize the vitality of the whole Social Security system. And the court stated this for two reasons. First, that it is the largest public funds network in the United States. Social Security serves over 68.5 million people in the 2024 fiscal year. And by comparison, the VA serves 6.7 million veterans in that same fiscal year. This court emphasized how the size of that.
So the protection against, say, I'm going to say fraud and abuse, just as a shorthand, only gets to have this special value with respect to the highest government program.
No, Your Honor, but however, a major emphasis in that case was the size of Social Security and how it would be.
I mean, veterans' benefits are pretty big.
Yes, Your Honor.
It's a lot of, just have to read the Washington Post over the last few weeks to see about that. And so are we really dividing up this idea that the government has a compelling interest in protecting Social Security, but not a compelling interest in protecting the integrity of these other programs?
Yes, Your Honor, because not only the different size discrepancies, the VA already affirmatively allows individualized assessments, showing that it would be no more burden on the court to evaluate these religious objections, which is what this court in United States versus Lee was concerned about. With the good cause exceptions, each veteran's claim is looked at individually, and so this would be placing no more burden on the VA than is already written into their policy.
I don't understand that. So in terms of the compelling interest, I don't understand how that plays into the compelling interest. If the compelling interest is designed to prevent, I'm just using the shorthand, fraud and abuse, and I'm not saying that Mr. Scout is committing fraud, but the idea of the examination is designed to make sure that paying somebody 100% disability is still warranted. I don't understand how having the good cause exception undermines that value.
Yes, Your Honor, even if there is a compelling interest, the statute still fails strict scrutiny because it is not narrowly tailored, nor the least restrictive means. For example, in Holt versus Hobbs, this court found the policy unconstitutional because they failed to prove why denying the extra half-inch of beard length would jeopardize their compelling interest. And here, the VA has done the same. I see my time has lapsed. May I briefly conclude?
Yes, why don't you finish up?
Thank you so much. Here, the VA has provided rhetorical justifications and general assertions as how this would harm the VA policy. As this court stated in Wisconsin versus Yoder, that is prohibited. And for these reasons, this petitioner respectfully requests that this court reverse the Federal Circuit Court of Appeals and find the VA mandatory medical exam policy unconstitutional. Thank you.
Thanks a lot. Ms. Hussey?
May I proceed?
Absolutely.
Chief Justice, Your Honors, and may it please the court. My name is Hannah Hussey, and I, along with my co-counsel, represent United States Marine Corps veteran, Mr. Mark Scout. Your Honors, this case is about a veteran who served to protect our freedoms and then was denied his own. Accordingly, petitioner respectfully requests that this court reverse the decision of the Court of Appeals for the Federal Circuit for two reasons. First, that the board erred in failing to review Mr. Scout's evidence, and two, that the Court of Appeals exceeded its jurisdiction by engaging in de novo fact-finding, and this was prejudicial to Mr. Scout. Your Honors, Mr. Scout is a 64-year-old Marine Corps veteran who served at Camp Lejeune and was exposed to contaminated water. As a result of his service, he was left with stage 4 chronic kidney failure and battles lifelong disabilities. Just 1 year after Mr. Scout underwent a kidney transplant, the VA slashed his benefits from 100% to 30%, the minimum possible rating for stage 4 chronic kidney failure and cut his benefits in over $3,000 a month. Mr. Scout made a great sacrifice in serving his country, and only now does he ask that his country honor that sacrifice in hearing the evidence he has placed before it. This brings me
Well,
to...
but did your client place the evidence before the board?
Yes,
I
Your
mean,
Honor.
doesn't it beg the question, right? So let's get to the question. Why is it that providing a web link is providing the evidence to the board?
Yes, Your Honor. As noted on pages 26 through 30 of the record, Mr. Scout provided the exact URL directions to access the video of his naturopathic healer, Mr. Hale. Further, in Bowie versus West, the appellant provided only tenuous reference to 2 documents they wanted before the record. These documents were merely referenced in other documents and were never submitted to the board. The court in Bowie held that the board need not investigate, gather, and consider such documents on its own. Here, in contrast, Mr. Scout provided direct access to his naturopathic practitioner's video in the only means it was available to him. His board hearing, as noted on page...
Wasn't the board obligated to find, visit, and digest the information on the webpage?
No, Your Honor. Here, this is not the tenuous amounting of evidence that the board in Bowie was concerned about. Here, Mr. Scout provided the exact URL to the video in tandem with a physical report authored by Mr. Hale. This report is noted on page 31 of the record. In addition, as noted at his May 2023 board hearing, Mr. Scout was adamant that the board must review this video and that it would be critical in engaging in his claim for benefits.
Here in this case, the board said that this is an AMA case, meaning it's in the modernized system. And the board said that it could consider evidence that was submitted at the board hearing. So getting back to the Chief Justice's question, what is the evidence that you're alleging was submitted here? Is a link evidence?
Yes, Your Honor. Here, Mr. Scout...
What does it tend to prove or disprove?
Well, Your Honor, yes, Your Honor. The link itself goes towards the competency of his naturopathic practitioner. As Mr. Scout was adamant...
Content of the video, not what was provided at the hearing. And under 7113B, which is what the board was referencing, the board may consider evidence submitted by the appellant at the board hearing.
Yes, Your Honor. However, this must also be read in tandem with the VA's duty to assist, even through the appeals modernization.
This is an AMA case.
Yes, Your Honor. However, even through the Appeals Modernization Act, the VA duty to assist is still present. The VA...
But not before the board.
Yes, Your Honor. However, this was submitted to the board through Mr. Scout's hyperlinked evidence. In addition...
Yes, but I think that's what just Meredith is talking about. So HTTP whatever blank doesn't tend to prove or disprove anything, right? I mean, just doesn't prove or disprove anything. So don't you have to make another step, right? Which is that's not evidence, but it leads to evidence because you got to do some stuff to get to what this is.
No, Your Honor. This was evidence as Mr. Scout provided the exact hyperlink evidence to exactly what he wanted the board to consider. This address was given just 1 month prior to Mr. Scout's May 2023 hearing before this board. And as such, the video was likely the only means that he was able to provide this information to the board. Further, at his board hearing, as noted on pages 29 and 30 of the record, the judge stated that they would carefully review all of the evidence brought before them at that hearing in making their decision.
So this is going to date me, and I don't even know if people of your generation know what this is. Do you know what the Dewey Decimal System is?
Vaguely, Your Honor.
Vaguely. Well, okay, it's those weird numbers that if you go to a public library on the side of the book, KF 1.7, whatever. So assume that your client had given to the board member a Dewey Decimal reference that was a precise, just like this, took you right to the thing. The Dewey Decimal number at a library would bring you right to the book. Would that be evidence?
Well, Your Honor, in your hypothetical, it depends if this book was located in the Board of Veterans Appeals. Here, this website was directly accessible to the board.
How do we know that?
Because, Your Honor, the board was able, if the board had typed in this evidence, it would have brought them directly to the video that Mr. Scout was purporting them to find.
You're assuming that, aren't you? There are lots of things that in the government computers won't let you go to. You can't do online shopping, for example. We were just discussing this before. But strangely, you now can look at Peacock. But so does it matter if a government computer would block YouTube?
Well, Your Honor, we do not know this fact because today part of the issue is that the board never went to the trouble of even trying to access Mr. Scout's evidence. Further, as noted on page 28 of the record, the board was able to review such digital evidence. The judge stated that evidence should be submitted to the court's digital upload system. Here, to hold against Mr. Scout would allow advances in modern technology to disadvantage Mr. Scout and hold this court to a precedent in Bowie versus West set nearly 30 years ago.
But so how do you reconcile that view with the actual language of the statute that you had to submit something at the hearing, something on YouTube, on the internet? How is that being submitted? Would you have to, better have had to reproduce it in some manner on a CD and physically given it to the board member to be able to submit it? How do you view the word submit in that context?
Yes, Your Honor, while the statute does state submit, here in a pro-veteran system, Mr. Scout was adamant that the court and the board rather must review this evidence. He brought the exact hyperlinked URL address to his hearing, and the board never stated that they would not be reviewing it in their decision. They never stated specifically that he must upload this link in order for them to view it. They simply stated that all information from the board hearing would be carefully reviewed in making their decision, and they thanked Mr. Scout for his service and submitted the claim.
If wasn't evidence submitted at the hearing, how did the board have authority to look at it?
Here under King versus St. Vincent's Hospital, this court established the now well-known canon that benefits for members of the armed services are to be construed in the beneficiary's favor. Congress has also echoed this sentiment and held that the VA has the duty to develop a veteran's claims for benefits to its optimum before deciding on the merits. Here, the VA, if they required additional information in granting Mr. Scout's claim, they had a duty to inform him of what additional evidence he needed to submit. Additionally, as noted on page 52 of the record, Mr. Scout originally stated when the VA gave him their notice of medical exam that he would not be attending due to his religious beliefs. However, the VA never responded to him and told him about different evidence that needed to be submitted. They simply gave him the decision that his ratings were being reduced from 100% to 30%. This brings me to my second point, Your Honors, that even if the VA could have declined to review the hyperlinked evidence, the Court of Appeals for Veterans Claims exceeded its jurisdiction by engaging in de novo fact-finding, and this was prejudicial to Mr. Scout. First, the board did not properly determine the competency of Mr. Hale. Under Nieves-Rodriguez versus Peake, the Veterans Court held that the VA is permitted by statute to accept a private medical report as sufficient as long as it is complete for the purposes of adjudicating the claim. While this language is permissive, under no circumstances does it allow arbitrary determinations when it comes to discrediting private medical advice.
And so in precisely what way did the Veterans Court engage in improper fact-finding?
Here, Your Honor, the board summarily determined that any evidence submitted by a naturopath would not be considered. Here, the board failed to consider that Mr. Hale provided that Mr. Scout was dealing with a 25 GFR over the past year.
So I don't mean to interrupt, but you've said in the response to my question, you've said the board twice. So I want to make sure we're on the same page. I'm talking about the Court of Appeals for Veterans Claims. How did the Court of Appeals for Veterans Claims exceed its jurisdiction by engaging in improper fact-finding?
Yes, Your Honor. Here, the Court of Appeals for Veterans Claims is prohibited in engaging in de novo fact-finding under both Deloach versus Shinseki in this court and Tadlock versus McDonough in the Veterans Court. Here, because the board never reviewed Mr. Scout's hyperlinked evidence, the Court of Appeals for Veterans Claims was statutorily prohibited from ruling that had they reviewed this evidence, it would not have impacted their result.
Well, that seems more extreme than at least I understand Tadlock and its companion case from the Federal Circuit, Stinson, to say. It's got to be that something is open to debate. So what is open to debate here?
Here, Your Honor, the hyperlink was never visited by the board. As such, the board could not find that this was not relevant for Mr. Scout's.
Well, let me give you a silly example, right? It can't be just that the board didn't review it. Let's assume that the Court of Appeals for Veterans Claims, the judge in that case, him or herself, clinks on the hyperlink, okay? And what it is brought to is a children's video about clowns. That's all it is. 5 minutes of clowns. Are you telling me that the Court of Appeals would be exceeding its jurisdiction to say it doesn't matter that the board didn't look at this because had it looked at 5 minutes of clowns, wouldn't have changed it?
In your hypothetical, Your Honor, no, the Court of Appeals would not necessarily be exceeding its jurisdiction. However,
well, not necessarily. Is there any world in which 5 minutes of a video of clowns would be relevant to Mr. Scout's claim?
no, Your Honor.
Okay, so then it's got to be that something in the video that we have, something, would be open to debate. So what is the thing that is open to debate?
Yes, Your Honor. Here, what is open to debate is whether a naturopathic practitioner can opine on Mr. Scout's GFR. Here, naturopaths are licensed and recognized in Wisconsin under Wisconsin Statute Chapter 466. Here, the board did not rely on any of this information in its determination that Mr. Hale could not opine on these symptoms. I see my time has lapsed, Your Honors. May I briefly conclude? Here, the board did not rely on any of this information in determining that Mr. Hale could not testify about Mr. Scout's symptoms. They simply held that on page 23 of the record that the hyperlink was not accessed nor considered in making their decision, and that they were affording Mr. Hale's report no probative weight, despite the fact that Mr. Hale had 40 years of experience and gave a 25 GFR for Mr. Scout. Accordingly, petitioner respectfully requests that this court reverse the decision of the Court of Appeals for the Federal Circuit. Thank you.
Thank you very much, Ms. Hussey. Hear from Secretary's Counsel.
May I proceed?
Yes.
Good afternoon, Chief Justice, and may it please the court. My name is Clayton Smith, along with my co-counsel, Ms. Valeria Gilmodinova, and together we represent the respondent, the Secretary of Veterans Affairs. Your Honors, this case is about preserving a fair, uniform system that treats every veteran equally. On the second issue, my co-counsel will explain why the Board of Veterans' Appeals did not err. I'll begin with the constitutional question. The Federal Circuit's decision should be affirmed for two reasons. First, Diagnostic Code 7531 is neutral and generally applicable. And second, even if strict scrutiny did apply, VA's interests in fiscal integrity, uniform administration, and accuracy are compelling, and the rule is narrowly tailored to achieve those interests. Before I turn to my first point, Your Honors, I just want to take a brief moment to begin with the points that we do agree with the Petitioner's Counsel. First and foremost, there is no question here as to Mr. Scout's sincerity of his religious beliefs. And from there, I want to take a step back and address some of this court's questions with respect to.
So let me jump in there. So even if VA is not contesting the sincerity of his religious beliefs, are we bound by that? Can we still challenge or discuss whether or not the beliefs were sincere?
No, Your Honor. Because to look into the sincerity, petitioners noted Hobby Lobby versus Burwell, and in that case, the court explained that looking into the sincerity of the petitioner's belief was a step that went beyond this court's role.
Thomas suggested that if an assertion was so bizarre, so clearly non-religious, then it would not be subject to protection. So you're suggesting that we wouldn't be able to look at the veteran's statements that he thought VA doctors were quacks and that they were unqualified to determine whether he had a sincerely held religious belief that was preventing him from attending the exam.
I understand your question now, Your Honor. So if there was an example that a situation where the claimant's beliefs were in question, then this court could inquire into that, but that isn't the case here. We agree with petitioners that this belief is sincere. And moving on from there and taking a step back, I want to clarify the analysis between neutrality and general applicability are two different stages. As the Chief Justice alluded to in Lukumi, that case involved a targeting of religion on the face of the statute. That targeting is not present here because, as the Chief Justice pointed out, the list here is non-exhaustive. Here on Joint Appendix page 52, as Justice Meredith pointed out, petitioner did not seek an accommodation from this exemption. Instead, he referred to the VA doctors as quacks and that he would no longer want to be touched by them. So that speaks to—
Doesn't that implicitly seek an accommodation, examination by somebody else?
Possibly, Your Honor. I think here VA does allow for alternative evidence and examinations in alternative ways, but that wasn't requested here. And so moving on from the lack of this regulation is neutral on its face because it does not target, as the Chief Justice pointed out, it isn't targeting religion because the list is non-exhaustive.
So, but given your initial concession in response to Justice Meredith, about the sincerity of the religious belief, would you agree that the application of this policy about the requiring the examination does have an effect on Mr. Scout's religious beliefs?
Yes, it does have an effect.
So are you familiar with a federal statute called the Religious Freedom Restoration Act?
Yes, Chief Justice.
So as I understand the Religious Freedom Restoration Act, it basically says that even if something would be subject to rational basis scrutiny under the First Amendment standing alone, if it's a congressional act, Congress has said, we want you to apply strict scrutiny, right?
Correct.
So why isn't the debate between the parties about strict scrutiny versus rational basis scrutiny much ado about nothing? Because whether or not under the First Amendment standing alone, we would apply rational basis scrutiny here, Congress has said we need to apply strict scrutiny. Are you following me?
I think so, Chief Justice. So as the way that I understand it, RFRA applies to the federal government, but there is a distinction between analyzing a constitutional question under RFRA and under the First Amendment. This court explained that RFRA was a different analysis, that going straight to strict scrutiny under RFRA is different than a constitutional analysis.
So is this, my words, not yours, a situation of whether it's waiver or forfeiture on the part of the petitioner to invoke the analytical framework of RFRA, we're left with the First Amendment writ large, and therefore then we do have to engage in the question of Smith versus City of Hialeah.
That's precisely correct, Your Honor. And so here, moving on to what is really my first argument here, is that the rule is generally applicable because it does not create individualized exemptions. And individualized is the operative word there. The list in section 3.655 provides some examples of what may qualify as exemptions. And as the Chief Justice pointed out, it is not an exhaustive list. It reads, includes, but is not limited to illness, hospitalization, or death in a family, etc. Now that list should be read under statutory interpretation principles, adjustum generis. Scalia Garner talk about this on page 199 of Reading Law. When a list includes two or more objects or items, that list should be read to be confined to similar items in that list.
So could a religious belief ever qualify as good cause in your view?
Yes, Chief Justice, it could. But the different—
No, go ahead.
The difference here is that the exemption being sought is a permanent exemption. And those lists, the category of items there are temporary exemptions. And so Ultimately, what the petitioner is seeking an exemption from is the underlying evidentiary requirement.
So, but doesn't, and I understand, I understand that point, but doesn't that though, you said that it can accommodate a religious exception, except it would have to be somebody who's really flighty, right? Who's like, today I believe this and maybe tomorrow I won't. I mean, assuming somebody actually believed that this violated the spirit of the cosmos or whatever it is, unless he or she changes her mind, it will be permanent because religious beliefs tend to be permanent. Right? So doesn't that really mean that it doesn't accommodate a religious exemption?
No, Chief Justice, because, for example, if the petitioner sought a temporary exemption for attending a religious ritual, like Mass, for example, that could be a temporary exemption that would be granted. But here,
You think that a religious good cause would have to be because the exam is scheduled for the Sabbath or a religious holiday?
it may not necessarily be confined to that specific, but what I'm trying to get at is that the exemption cannot be permanent. If there is a practical infeasibility, it doesn't necessarily equate to a permanent exemption. And so here, the rule is generally applicable because it's confined to a particular category. But even if this court did find that strict scrutiny applied, the rule is narrowly tailored to serve VA's interests in fiscal integrity, uniform administration, and equal treatment of all veterans. Because there is no less restrictive way for VA to achieve those interests.
Back to the issue of general applicability, in the joint appendix at 48, in December 22, VA's in their rating decision proposing to reduce the veteran's rating said that the veteran did not attend the examination due to religious beliefs, but did not ask for accommodation. The VA may have been willing to provide an accommodation based on his religious beliefs. What does that do to whether or not this is a generally applicable provision?
I don't think it changes the analysis, Your Honor, because as I spoke a moment ago with Justice Jaquith, there may be a situation where a religious exemption may be provided, so long as that it's limited to the category of temporary infeasibilities.
Well, what type of accommodation would they provide in the light? That's not what this sentence is talking about, is whether he showed good cause or not. It says he didn't ask for an accommodation.
So accommodations can be providing alternative ways of submitting evidence. It doesn't necessarily need to be the mandatory examination. Under 3.655, the good cause clause, it allows for 60 days to submit alternative evidence. And as Your Honor pointed out on page 48, that was the initial proposal to reduce. It wasn't until February 22nd, 2023, 60 days after that proposal, when Mr. Scout's rating was actually reduced. So during that time frame, he had the opportunity to submit that alternative evidence to support his claim. But that evidence was not submitted during that time frame. So that's the issue. And getting back to the strict scrutiny analysis.
What if the permanent bar to having the mandatory examination was a disability so serious that the person could not possibly get to a VA examination site?
Then VA may be inclined to provide accommodations to allow an examiner to go and examine the individual there. Or if the individual is in a hospital, for example, there would be ways for VA to rate the individual in those circumstances. But
how is that different than accommodating the religious exercise by this veteran?
Well, VA here did not deny any accommodations to the veteran because he didn't ask for it. Had he asked, he may have been provided them, but that isn't the case here. And so in this case, under 38 USC,
They offered to do that?
they did not offer to do that, no, Your Honor. In part because he didn't ask for that. Had he asked for that, there would be a different story. But returning back to the strict scrutiny analysis, under 38 USC 1155, Congress tasked VA, and consistent with the AMA, it tasked VA with modernizing its system. And that's, again, what Congress tasked VA with under the AMA. And so it had a system from 1994 through 2021 under 38 CFR 4.1158. And under that system that existed for 27 years, VA did accept symptomatology. But the result of that, the consequence of accepting symptomatology and rating kidney residuals, was that the system led to inconsistent application and unfair results for some veterans. Veterans were treated differently. So in response to that, VA proposed to change that rule to objective evidence under GFR ratings in 2019. Went through 2 years of notes and comments, and finally produced the final rule in 2021. And the underlying reasons there were, again, fairness, accuracy, and uniform administration. So again, that was a task from Congress that VA complied with to modernize its system. And there's no less restrictive way for VA to achieve its interests in rating veterans under Diagnostic Code 7531, because what petitioner is seeking to do here is introduce that symptomatology. Rating GFR requires objective medical data. What VA did provide was an option to submit alternative evidence.
So, this is where the two issues sort of come together, right? Because would it be in an appropriate case that the submission of a non-medical doctor, say a religious practitioner, such as the one here, could be an alternative means to establish the evidence here, if the board were to conclude that that practitioner were qualified to submit that evidence?
So I have two things to respond to that, Chief Justice, and my co-counsel will speak at much more length and much more eloquently than I can. But in this particular issue, the ratings, the requirements in determining whether it's qualified requires training, education, and experience. And it also requires that training, education, experience to apply principles based on the facts and data before it. Here, the naturopath submitted a letter in April of 2023 that was conclusory, and the board found it so.
Right. So, and I wasn't meaning to take you into your co-counsel's argument. My question to you on your argument is, in a world in which those defects that you're discussing about this particular piece of evidence, would it be the kind of thing that if the evidence were better coming from a non-VA doctor, could that satisfy the requirements of the diagnostic code as a proxy for the exam?
Yes, if the evidence was better, it could satisfy it as a proxy. Yes, Chief Justice. And using the kidney disease improving global outcomes is the gold standard for measuring these things. They did a study in 2012 and found that using a GFR, an estimated GFR rating, is the best way to establish this kidney residuals. So I see my time is about to expire.
Take a moment to conclude.
For the reasons that I've discussed, Diagnostic Code 7531 is neutral and generally applicable. But even if strict scrutiny applied, VA has no alternative way, no less restrictive means to achieve its interests in fiscal integrity, uniform administration, and accuracy. Thank you.
May I proceed?
Absolutely.
Good afternoon, Chief Justice, Your Honors. May it please the Court. My name is Valeria Gilmudinova, and I will continue our presentation on behalf of the respondent as I address the final issue. This court should affirm the lower court's decision and find that the hyperlink was not on the record before the board, and further should find that the Veterans Court did not conduct de novo fact-finding during its harmless error analysis. Moving to the government's first point, VA has no duty to consider hyperlinks proffered as mere references because they're neither relevant nor reasonably connected to the petitioner's claim. Chief Justice, you pointed out that under 38 U.S.C. Section 5103 AE2, Congress expressly terminated the duty to assist once an appeal reaches the board level. And the petitioner was on notice of this, as we see on page 80 of the joint appendix.
So let me ask you a question here. So you are not saying that the board would be categorically prohibited from viewing a YouTube video, right?
Yes, Chief Justice.
Okay, so how would you go about submitting a YouTube video to somebody?
Chief Justice, there are a number of ways that a video could be submitted. Page 80, or I apologize, pages 40 and 44 establish some of the ways that VA can receive evidence. It includes utilizing va.gov via the direct upload that was brought up during the petitioner's argument. They could also bring evidence in person at a regional office, or they can mail it or fax it in.
So how would you fax in a YouTube video?
Chief Justice, the transcript of the video could have been put into a PDF, and that could have been faxed over to the VA. Or if there are any visual aids that could have benefited the petitioner that were a part of the video, he could have submitted screenshots as well.
So doesn't that just seem, the technical legal term, wacky, right? I mean, that we're going to say that we're not going to let a board member do something that we all know how to do, which is even I, with my limited technological ability, can click on a link, right? But instead, what we're going to do is we're going to create a transcript, a written transcript of a YouTube video, and put that into something like a PDF. And then we're going to take any of the visuals that were on there and we'll somehow create them. And then we'll put that together with the transcript that we've created, and then we'll put it on a fax machine and send it to the board member, who probably will, at that moment, seeing it's a YouTube video, go to the YouTube video and watch it because it's a lot easier.
Possibly, Your Honor, but speaking specifically to URL hyperlinks, they can change. URL hyperlinks are not static. Individuals can post things, they can delete things. And specifically speaking, this was a YouTube video. We have no record of the authenticity of the video. So,
but isn't that one of the reasons why, because the hearing was a virtual one, spelling out the location for immediate access to the information, why wasn't that an acceptable way to get that information to the board member during the hearing, when there could be some confidence as to what it was, and the board member could ask any questions he had about it during the hearing and or follow up on any concerns that he had? What's wrong with that?
Your Honor, one of the points Chief Justice brought up was the fact that VA possibly may not have been able to access the video. Perhaps there was a malware or a cybersecurity issue. Additionally, the petitioner on page 29 of the Joint Appendix simply proffered the URL hyperlink, but he never actually notified the board as to exactly which parts within the hyperlink might be relevant or reasonably connected to his claim. This could result, as Bryan versus Shinseki decided by the Veterans Court in 2010 on page 496 through 497 of their opinion, found to be the VA having to scour the internet for privately hosted material, resulting in an unguided safari hunt. This is precisely the case that could have happened here because we do not know how long this video could have been. Further, this speaks to the third prong of constructive possession, which means that evidence will be submitted when it is relevant and reasonably connected to a claimant's claim. Davis versus McDonough, decided by the Veterans Court in 2023 on page 150, established that evidence is only before the board when it is both relevant and reasonably connected.
So isn't it doesn't this get to the question that I think Justice Meredith was asking your friend on the other side, which is, what is the evidence here? I mean, is it the evidence simply the hyperlink, right? In which case it's hard to see that the hyperlink proves or disproves anything of relevance here. Or is the hyperlink merely the door through which one passes? And so then you're in the world of the video. Which is, the government's position is, which is the evidence?
Your Honor, we're seeking that the evidence is the content that was contained within the video, which on page 29 of the Joint Appendix, the petitioner did state that while it may prove his claim, this was simply a community address or a community conversation regarding the naturopath's naturalistic healing approach through the cosmos and higher power that we see on page 31 of the Joint Appendix.
So then you will accept then that the relevant, quote, evidence for purposes of our analysis, and I'm not saying that the evidence is relevant, I'm saying the thing that is evidence is not simply the hyperlink, it's what the hyperlink linked to.
Yes, Your Honors. And speaking directly to the relevance aspect.
And the naturopath's qualifications were very much at issue, weren't they?
No, Your Honor. On page 31 of the Joint Appendix, we can see that the naturopath did provide some of his credentials. He stated that he had 40 years of acting as the conduit in channeling the cosmic power of the higher power. But speaking specifically to the relevance aspect, Bowie versus West, decided by the Veterans Court in 1998 on page 109 of their opinion, found that relevance speaks to how tenuous of a connection evidence has to proving the petitioner's claim. In our case, page 22 of the Joint Appendix establishes that the petitioner's claim is a complex medical diagnosis that requires objective criteria.
So the board never looked at the what you've conceded is the evidence, right?
No, Your Honor, they did not. And that speaks to the reasonably connected to a claimant's claim, which Bowie versus West further found that speaks to how reasonably it is to expect the VA to conduct further investigation, gathering, or consideration. In this case, they would have to conduct further investigation because on page 29 of the Joint Appendix, the petitioner never actually...
It couldn't be more directly connected to the veteran's claim. The veteran submitted it in the hearing. The reasonably connected to the veteran's claim issue arises when it's a study that was done in San Francisco, and the question is whether it applies to a Camp Lejeune water case of a different veteran. This veteran submitted this information, evidence for consideration by the board.
No, Your Honor, the petitioner did not actually submit the URL, the evidence. He submitted the URL hyperlink, he verbally proffered it, but that was not actual submission. He was on notice of how to submit evidence, and he did so. He submitted the naturopath's report that we find on page 31 of the Joint Appendix. Further, on page 30 of the Joint Appendix, the Veterans Law judge presiding over his hearing notified him that he had 90 days under AMA to present additional evidence, and that she was looking for anything that could prove or disprove that he warrants a rating above 30%. This should have shown the petitioner that the hyperlink was not submitted, and that the VLJ was still looking for additional evidence to prove or disprove his claim.
But if the board member wanted the evidence in another form or submitted it in a different way, wasn't he obliged to say so? Isn't that part of his Bryant duty?
Yes, under Brian Mishuseki, they do have to suggest missing evidence as one of their duties, and the VLJ judge on page 30 of the Joint Appendix did exactly that. She specifically stated that she's looking for anything else that could prove or disprove him warranting a rating above 30%. Further, this would still require the board to conduct that additional fact-finding that Bowie stated is not reasonable for the board to do.
So, but why should, now, of course, we're not bound by Bowie, but why should we even pay attention to a case that came in the period before the internet, right? I mean, at that time, you give somebody, a reference, they're going to have to go to the library or do something. Now you give me a reference, I can sit in, the comfort of my office and type something into the computer and it will magically bring me to that thing. So whatever would have been the burdens that Bowie was concerned with, haven't they changed dramatically?
No, Your Honor, because internet links are, again, they're not static, they're not permanent. They can change, information can be added. If that URL hyperlink was offered into evidence and then looked at a week later, that same information that was there the day of the board hearing may have disappeared, or it may have been edited. Further, again, there is no authenticity piece to the evidence that was provided.
But then all of that is true, right? But why then does that make it okay for the board to do what it did here, which is just say, heck no, I'm not looking at it at all? It could have been that the board looked at it and said, I think that this has been altered. I noticed that the date is after the date of the hearing, right? But the board didn't do any of that. It just said categorically, and I understand the United States position to be categorically, a website is not something that then is evidence to which we look.
Your Honor, because under Wood versus Derwinski, decided by the Veterans Court in 1991, page 193 of their opinion, found that the duty to assist is not a one-way street. And this is precisely what should have happened here. While we do understand that this is a non-adversarial system and it is pro-veteran, it is pro-veteran for the 15.8 million veterans that are currently receiving VA disability benefits.
So why wouldn't then, to stick with Judge Jaquith's question, so I would think that most people would think, if I want somebody to look at a YouTube video, the best way that I can get them to do that is to give them the URL address for the YouTube video I want to look, right? Why wouldn't the board member have an obligation upon getting the URL to say, I understand that everybody else in the world would click on this, but I can't. If you want me to look at this, you have to give me this in another form, because it's counterintuitive that you wouldn't use the link.
Yes, Chief Justice, but the BLJ on page 30 of the Joint Appendix did precisely so. While she did not necessarily speak directly to the hyperlink, she did state that she was still looking for additional evidence that could have proved or disproved the rating warranting over 30%. However,
Well, but if I were to look at that, I'd say, without saying anything about the URL, you would assume that somebody has looked at the URL, wouldn't you? Isn't that the more natural assumption?
possibly, Your Honor, but I cannot speak to the mental state of the petitioner. Further, the Veterans Court did find that the hyperlink was on the record before the board and conducted their harmless error analysis. So moving to that issue, the Veterans Court was within their jurisdiction to conduct that analysis because they had the authority to uphold on grounds different from the board if the administrative record made it clear no other conclusion could be found.
So how is it clear here that it is, in the words of the Federal Circuit, assuming we were to adopt that as the test, that it is a matter beyond doubt, right? Beyond doubt that the Veterans Court could reach the conclusion about this information either not being relevant or not changing the needle, or however we want to describe it.
Chief Justice, under Tadlock v. McDonough, decided by the Federal Circuit in 2021 on page 1337 through 38 of their opinion, they found that when additional findings of facts are necessary, that is when the Veterans Court crosses their line. However, speaking directly to the competency aspect, 38 CFR section 3.159A1 found that competent evidence can come from a person who is qualified through education, training, or experience. And Neves Rodriguez versus Peake, decided by the Veterans Court in 2008 on page 302 of their opinion, found that a medical opinion is competent only if it rests on sufficient facts or data, employs reliable methods and principles, and then applies those reliable methods and principles to the case at hand.
So how can either the board or the Veterans Court properly determine that the video wouldn't have affected its finding about the naturopathic practitioner's competence without actually reviewing the video?
Because, Your Honor, speaking directly to just the report on page 31 of the Joint Appendix, we see the type of symptomatology that the naturopath was utilizing in his opinion. There was fatigues, body aches, a spiritual heaviness resulting in a persistent darkness around the kidney. However, those symptomatologies can lead to a number of different disabilities and not necessarily a complex heavily medical complex diagnosis of a GFR requiring a level of 25.
But that separate exhibit doesn't give any clues about what the YouTube video says.
Page 29 of the Joint Appendix makes it clear that the video simply is a community address to the community that the naturopath discusses healing through the cosmos with. However, those don't lead to reliable principles because, again, they can result in a multitude of different other disabilities that could be seen through those four symptomatologies that were presented on page 31 of the naturopath's report. Further, Shinseki versus Sanders, decided by this court in 2009.
So we're back to a competence determination without hearing the evidence that the veteran proffers about the competence of his examiner.
Chief Justice, I do see my time has expired. May I briefly respond?
Yes, you can respond, and then you can take a moment to brief.
Speaking directly to his competence, Your Honor, he provided he had 40 years of experience of channeling the cosmic powers, but the principles that he uses are not reliable because they can lead to a multitude of conclusions simply because they are physical symptomatologies that don't necessarily meet the objective criteria of a GFR of 25. And to conclude, for these reasons, we ask that the court find that the hyperlink was not on the record before the board, and further that the Veterans Court did not conduct de novo fact-finding.
And Petitioner, I think you've reserved a couple of minutes for rebuttal. Ms. Hussey?
May I proceed? Chief Justice, Your Honors, and may it please the court. First, as Your Honor stated, competency of Dr. Hale is at issue here. In contrast with respondent's contention, Mr. Hale's evidence was both relevant and related to Mr. Scout's claim for benefits. The report on page 31 of the record states Mr. Hale's 40 years of experience in naturopathic medicine, in addition to his 1 year of experience treating our client, Mr. Scout. Mr. Hale was the sole person who was treating Mr. Scout for his renal symptomatology over the past year, and therefore his conclusions were relevant to the board's determination. Further, as noted in Wisconsin Statute Chapter 466, naturopaths are licensed and recognized medical providers in the state of Wisconsin. They are able to do everything that other medical doctors can do in the state except for surgery on patients. Here, the board failed to take this into consideration, including the fact that on page 31, Mr. Hale's report cited a 25 GFR that directly coincides with an 80% disability rating, as noted on page 22 of the record, and stated specific symptoms such as fatigue, body aches, and chills that coincide with Mr. Scout's stage 4 chronic kidney failure. In addition, under strict scrutiny, when a less restrictive means exists, a policy fails. In just January of this year, Harkins versus United States held that when the Coast Guard failed to propose a less restrictive means, it failed. Here, Mr. Scout affirmatively provided alternative medicine and evaluations that the board failed to consider, that they must consider under Nieves-Rodriguez versus Peak. Respondents stated that the VA was willing to accommodate Mr. Scout. However, as to date, this has not been the case. The board flatly refused.
Did your client ask to be accommodated?
No, Your Honor. However, as noted on page 52 of the record, Mr. Scout did provide that he had religious objections to the VA exam. The board then refused. I see my time has lapsed. The board then refused to review any additional or supplemental evidence he placed before it. For these reasons, petitioner respectfully requests that this court reverse the decision of the Court of Appeals for the Federal Circuit. Thank you.
Well, thank you to all counsel for the helpful argument. The case just argued is submitted. We are going to recess for a brief time, and then we'll come back.
All right.
No, you can all sit. We get enough of people standing all the time. Well, thank you, everybody, for coming, and all the people back in the peanut gallery. This is a fun event for the court. We were glad that as events dropped because of the, as we call it, the lapse in appropriations here in Washington, we were able to keep this moving with some funds that didn't require current spending, and so we were able to do that today. It's always a pleasure for me to do this. Before I got my current gig, I was a law professor and was a coach of a team at the very first moot court competition the court held in 2009. And so it's sort of a long journey to then be up here. But we're just going to give you some very brief thoughts before we then proceed with the award ceremony. I'll start with our junior judge, Judge Jaquith.
Not surprisingly, since it's the finals, all of you did great jobs. It's a little hard to get in with questions sometimes, which maybe it's a good advocacy technique. I'm not for competition, perhaps. In actual appellate advocacy, not so great, because we want to get our questions answered. So we like to be able to get in to have that happen. And there was some, I think, as is common, you guys were really well prepared, and so stayed on message, however much we tried to divert that. And sometimes that can be frustrating to us when we're trying to get answers to questions. But all in all, I thought y'all did a great job.
Judge Meredith.
I agree. I was really impressed by the command of both the facts and the law, and the ability to cite the records, to cite specific cases in response to questions. I thought everyone had really good decorum for the courtroom and were very respectful. I liked that everybody maintained sort of what I call like your lawyer voice. They're not slipping into speaking more, not as formally as you should in a courtroom. I thought that was all really good. I agree with Judge Jaquith that, you might want to watch your cadence if you're really just trying to jam a lot in there. It doesn't make it as easy to have sort of a conversation with the judges is what we're kind of going for in most cases. But overall, I just thought that was very impressive from everyone. So thank you for being here.
Yeah, and from my perspective, I concur with my colleagues on this point. Of all the years that I have judged the moot court competition, this has actually been the closest of the final rounds that I've been in, and it took us a while to wrestle through all of this. What I would just underscore, first of all, I agree 100% with Judge Meredith that you were all very professional in the courtroom. You would be surprised that sometimes people do things where you wonder why. Why they made that choice. And so, but also the other thing that just I encourage you to think about as you move forward in your career, and we call it the practice of law for a reason, right? Practice is, if you go into an oral argument and you end up not reaching a single point you wanted to make, but you engaged in a back and forth with the panel, it's been a good oral argument, because everything that you wanted to say should be in your briefs anyways. But if the judge is talking to you, then you're successful. Two things, and then I'm going to turn it over to, I guess, Judge Jaquith for the awards. One is the sort of worst thing that somebody ever said to me during an oral argument as a judge, and it was from the government in this case. And I asked a question, and the lawyer actually said to me in a real oral argument from that podium, well, that's not the question, Your Honor. And I said, oh, I think it is, because I actually even asked it with inflection in my voice, right? And so, because even though what he was saying was, that's not important, it was important to the judge. And so then you either have to get that judge off the wrong track and get it on the right track, but you want to do that. But the other thing I'll say is too, just this idea about being entirely honest with the court. And I don't mean like just not lying. The best answer I ever got was also from the government in a case. I said, listen, we've got these two statutes. If I read one, it points in one direction. If I look at the other, it points in the other. And I said, I just don't know how to reconcile them. And the lawyer, a young lawyer from the government, said, Your Honor, I've been thinking about that for the last few weeks. And I have to tell you, I don't know. He said, I'm going to give you my best shot about why I think the government's position is the better one. But I don't exactly know how to do this. And that answer of I don't know was one that really carried a lot of weight, because it showed that, okay, this is a case where we've got this issue, it's not made up, and now I'm going to go on. And not only did that, I don't remember whether the government won in that case or not, but what I do remember is that every time that lawyer appeared before me after that, that lawyer started with a reservoir of sort of goodwill because of that answer. So when you're going out there and you're practicing, remember, it's this case, you definitely have to do that, but everything you do in this case is going to carry on into the other cases you have. And so you're all really well situated at this point, and it was a real pleasure. So with that, I'm going to turn it over to Judge Jaquith, the chair of the court's outreach committee.
I'm sure you all know that Veterans Day is November 11th because that is when the armistice was signed in 1918, ending World War I. It just looks like I was there. Then thought to be the war to end all wars. The armistice was signed at about 5 a.m. to become effective at 11 a.m., the 11th hour of the 11th day of the 11th month. But there was no ceasefire to cover the time until 11, and thousands were wounded or killed that morning, the last American being Henry Gunther of Baltimore. U.S. President Woodrow Wilson told Congress that the great nations which associated themselves to destroy it have now definitely united in the common purpose to set up such a peace as will satisfy the longing of the whole world for disinterested justice. But it would take 70 more years for justice in the form of independent judicial review to be afforded veterans' claims, and with it, some recognition that attorney advocacy for veterans sharpens the identification and presentation of the relevant facts and applicable law, hastens resolution, and increases the likelihood of an appropriate outcome. The court is so grateful for the partnerships that have made this competition happen and happen annually since 2009, making this the 17th National Veterans Law Moot Court competition. We're honored this year to have Chief Judge Michael Allen and Judge Amanda Meredith on the bench. Both have been on the court for 8 years, and both are premier veterans law experts. Among the accomplishments in their storied careers, Chief Judge Allen served as Associate Dean of Stetson University's College of Law and founded the Veterans Law Institute there. And Judge Meredith served as General Counsel to the Senate Committee on Veterans Affairs, and before that as Executive Attorney to the Chief Judge of this court. Thank you, Chief Judge Allen and Judge Meredith. Big thank yous also to the co-directors of this competition, Dan DeLucia, now Deputy Counsel to the Board of Judges, who has led the way for so long that we should call the final arguments the DeLucia debate, and Laura Clayton, who led the problem development team that provides the substance of the program. And to my confidential assistant, Stephanie Allen, who is so important to the administration and logistics involved. And so now I'll turn the mic over to our producer, Dan DeLucia. Oh yeah, there it is.
With his box of goodies.
Yeah.
Pictures. Well, welcome to the court. I see a lot of familiar faces out there, competitors from yesterday, teams, coaches. Thank you for coming today. And thank you to all 28 teams that participated. We had 28 teams from across the country. And it was a really great competition both yesterday and today. I have a lot of people to thank, so I have my paper here so I don't miss anyone. First, we want to start with our partners in this competition every year, George Washington University School of Law, especially Dean David Johnson, who's been doing this for more years than I have. So thank you, Dean. And his team of TAs, we have Bianca Abate and Hana Waba, who were very helpful for us this year and recruiting judges and making everything work great yesterday. So thank you to the GW team. I also want to thank our sponsor, the CAVC Bar Association, who helped contribute to today's festivities and just were immensely helpful the whole time through. So thank you to the Bar Association. And one more thank you to the Veterans Consortium Pro Bono Program. They have been our trophy sponsors and our partners for many years. So thank you again for doing the same this year. The next thing I want to do is I want to invite Laura Clayton up here. Laura is the head of our problem development team, and I heard so many people say they really enjoyed the problem this year. It's a testament to Laura and her team. So I want her to come up and get her kudos. So Laura.
Yes, I did lead the problem development team, but I did not do it alone. Thank you so much to everyone who participated. A big thanks to Lauren Barefoot, McKenna Bonheim, Ryan Carson, Catherine Ebbison, Ashton Heppekhurst, Samantha Higgs, Alyssa Lambert, Amy Roth-Pixton, Patricia Scully, Mary Tang, and her Tesfaye, and Leanne Zobrist. They were wonderful, and it was so gratifying, I know, for all of us to see you competitors take the problem and run with it. And I would be remiss if I did not also thank Talia Grotto, Dana Ingracia, and Renee Reesner, who provided additional assistance with the bench.
Right, a couple more thank yous. We had a lot of volunteers from the court who were at GW yesterday on Saturday for judging the preliminary and quarterfinal round. So I'd like to give them a thanks right now. That's Kyle Atwood, Caitlin Biggins, Ryan Carson, Debbie Chu, Laura Clayton, Simone Coyle, Mavic Francisco, Ashton Habighurst, Samantha Higgs, Sonia Shah-Meze, Mary Tang, and her Tesfaye, and Leanne Zobrist. So thank you to all who came out on Saturday at GW and helped judge the competition. And then our thank yous for today, because we couldn't have done this without a whole team of dedicated court staff who helped pull this together and make it happen. So I want to thank everyone for their help today. I'm going to start with Stephanie Allen and Dawn Briquet, who are the heads of this real effort, and they're the ones who are responsible for bringing it together. So I'm standing up here, but they're the real heroes here. So thank you, Stephanie and Dawn. I'd also like to thank Ryan Carson, Laura Clayton, Rosie Garza, Carla Jones, John Leon, Tony Ortiz, Mary Tang, Sam Woodson, and Holiday Atkins for the help that they gave us. Again, coming in on a Sunday on their day off, I really appreciate it. So thank you to all the court volunteers, both Saturday and Sunday. I really appreciate that. I have some more court volunteers for that as well. First semifinal judges, Tiffany Wagner, our clerk of court and deputy executive. She was our semifinal judge, and she did her normal role for the final. So thank you. I'd like to thank Dave Quinn, who is the assistant chief counsel for the Department of Veterans Affairs. He was a semifinals judge as well. And James Drysdale, also a VA counsel, but who was serving in his capacity as immediate past president of the CAV Bar Association. So those were our semifinal judges, and they got to judge two semifinals back to back and did a great job. So thank you to all of you. And finally, to our final round judges, Chief Judge Allen, Judge Meredith, and Judge Jaquith, who gets a special shout out here as the head of the outreach. Thank you again for all your help and support in this. And I'm done with my thank yous, but now I'm going to invite up Steve Jordan, who's the executive director of the Veterans Consortium, and he's going to come and say a few words for us. Steve?
Allen, Your Honors, distinguished faculty, law students, mentors, friends of the court. The Veterans Consortium is pleased to be the longstanding award sponsor of this incredible competition. I'm a Navy veteran, so I particularly appreciate your interest in veterans law. The Veterans Consortium has been around for 33 years. We were formed at the behest of the court, and our formation is written in congressional statute. In 1992, there really wasn't much in the way of appellate defense for veterans. There really was no veterans law bar. So our mission was, and still is, really threefold as it supports the court. For one, we recruit, train, and mentor volunteer attorneys from across the nation to represent veterans. Second, we screen and place those cases with the veterans. So that's our Monday through Friday functions. We have some training opportunities, but what we're really doing is touching every single case that comes through. And these are for veterans that have no representation at that point. Then they're placed with their volunteer attorneys. And then thirdly, and I think maybe our staff enjoys this the most, we will cherry pick the most interesting cases and do some direct representation for those cases. So that's what we do in our day-to-day mission as we were formed 33 years ago. In addition, we have some additional functions as we've grown over the 33 years and gone from a collaboration from some veteran service organizations to a standalone 501c3, and we represent veterans in their discharge upgrade cases as it applies to their mental health issues. We have a citizenship program for veterans that for the pathway to citizenship for those that had a non-citizen status when they served the military. And then lastly, we support women veterans specifically in cases involving military sexual trauma. We're very pleased to do that. But in our role of the court, this is how we were formed, and really we really think this is the mission that grounds us. So the 30 folks that work at the Veterans Consortium Pro Bono program, we're very pleased with our roots, and that's really why we're here today. So last remark, a call to action. So for you in the audience, do pro bono, any kind. Very happy that you have an interest, at least today, in veterans issues, but the justice gap in our country is dire, and it will only grow during your time as you get your legal education. I think, and I'm not an attorney, I'm a veteran, so that's my feelings and my passion come through a gratefulness for the legal community, whether you're with firms, solo practitioner, in-house counsel, that generously give their time to support, in our case, veterans without representation, but the whole host of issues that need quality legal representation in this country. It's the best way that the legal community can make a difference, and in most cases, it's positively life-changing. So with that, I'll close. Thank you for your time and attention. Let's get to the awards.
Yeah, I come down here so I can facilitate handshakes. I don't know, picture taking. So maybe if award winners come over here, and then with any luck, I can put my back to the camera and we have a better picture. Okay, the first award is for the best oral advocate. Runner-up is Caitlin Stevens from Baylor Law School. Wow. And the winner, the best oral advocate, Clayton Smith, Stetson University. You can take my place, Dan. Okay, next. Best petitioner's brief. And although judges usually can't do this, but it's a three-way tie. So I'll go through all 6 names. Or I'll try to anyway. Megan Hofs and Isaac Swerling, Pepperdine University, Russo School of Law. Yeah, that's great. This is too many. Next, Sam Genzer and Christian Underhill, Lincoln Memorial University, Duncan School of Law. With all this hair, one of these things doesn't belong to you. And next, not least, Elizabeth Bowers and Hannah Hussey, Chapman University, Fowler School of Law.
Thank you so much.
Next is best respondents brief. And there are some special circumstances here. The runners up are Adam McGivney and Ryan Slattery, University of Wyoming College of Law. I don't think either one of them's here because they were to come from Wyoming and unfortunately, probably as a shutdown consequence, they weren't able to fly. A similar fate befell the winners of Best Respondents Brief, Alexandra Rye and Darren Stevens from Campbell University, Norman Adrian Wiggins School of Law. But when their flight was canceled, they drove. Being from Campbell, you should have ridden camels.
We should have.
Congratulations. Chief Judge. Okay. Now the teams. First, the semifinalists, Megan Hofs and Isaac Swerlin from Pepperdine, and Jacob Ayers Briseno and Miriam Scafide from South Texas College of Law in Houston. Come on up if you're here. I apologize for butchering your name.
Thank you. Thank you.
Okay, finalists. As Chief Judge Allen said, we really had a hard time choosing. It was kind of like a real case, talking about who's going to concur, who's going to dissent,
Who's going to write the opinion?
who's going to write the opinion. Then we realized we didn't have to do any of that. But we did have to make a tough call, and but we decided we didn't go with ties. So, but worth emphasizing how well all four advocates did, and how little separation there was. So the runners-up are Elizabeth Bowers and Hannah Hussey from Chapman, and the winners. The winners are Valeria Gilmudinova, not even close, and Clayton Smith from Stetson. Okay, thank you all for making the moot court competition a great one. Recognition of the value of attorney advocacy the value of attorney advocacy to veterans law continues to grow, and the enthusiasm, energy, and excellence the competitors have demonstrated this weekend foreshadows, I hope, continued fruitful growth in the years to come. It's hard to imagine that we missed anyone, but you are welcome to come up for pictures in the courtroom if you like. And please join us through there, or maybe go around that way in the Board of Judges conference room right behind us for cake and refreshments. Happy trails, safe travels, and maybe we'll see you or your school's representatives next year. Before you leave, anyone